What are the requirements for self-defense in Indiana? There are 4 requirements for self-defense in Indiana. Number 1, the person must be in a place where they are allowed to be. Number 2, the person must not have instigated or provoked the violence. Number 3, the person must have a reasonable fear of bodily harm or worse. And number 4, the amount of force used is proportionate to the urgency of the situation. Now, in order to be successful claiming self-defense in a court of law, all 4 must be present, and then a prosecutor would have to disprove at least one of those 4 elements. And if they were able to disprove one of those 4 elements, the self-defense claim would fail. But those are the requirements for self-defense in Indiana. Let's talk about them one at a time. Number 1, the first requirement for self-defense in Indiana is the person must be in a place where they have the right to be. What does that mean? Well, you can't break into someone's house and the homeowner is defending themselves and then you defend yourself back and then you say, well, yeah, I heard him, but I was only defending. No, you broke into the house. You have no right to be there. If you are at a business and the business trespasses you there, hey, you cannot come here. You're trespassed. And you keep coming back and security guard is trying to throw you out. You can't fight against security guards and be like, well, hey, they're throwing me out. I'm defending. No, you have to have the right to be where you're at in order to assert self-defense. That's the first requirement. The second requirement for self-defense is the person did not provoke or instigate the violence. So if somebody starts a fight and then the person they start the fight with starts winning, the person that started the fight can't grab a baseball bat and like, well, I had to grab a baseball bat. They're beating me up. No. You started the fight. Another person was finishing it. There's no self-defense claim because you started the fight and the other person was winning. You can't up the ante, grab a weapon in order to win the fight. It's claim self-defense. It's not how it works in Indiana. Now, there is a giant exception for that. If the person that started the fight starts losing and then they retreat and they make known that they're retreating, so they put their hands up, they yell, hey, I'm done, I'm sorry, I'm done fighting. Or they start running with their back turned from the person they started the fight with. Well, if they do those things, if they signal retreat, if they make it known they're retreating, they no longer want to fight, and the person continues to beat them up, well, that person can then claim self-defense. That is a hard argument to win, although it does win when the facts are all there and we have evidence. But in those cases, we really need some extra witnesses saying, yeah, the person started the fight, but they gave up. Or the other person was really aggressive and took it to the next level, but the first initial aggressor, he made it known he was done. So, can't start a fight and claim self-defense unless you make it known you're giving up and the other person won't stop. The third requirement for self-defense in Indiana is there must be a reasonable fear of bodily injury or worse. Now, reasonableness can get a little bit complicated. It's not super complicated, but it can get a little bit complicated because there's 2 components to the reasonableness. There's an objective component and there's a subjective component. The subjective component is pretty easy. The person who defended themselves must have believed it was necessary to defend themselves. So it's usually pretty easy to show the subjective because, hey, they actually did it. Or they tell the police when the police come, although you shouldn't talk to the police. Or they tell the police, hey, I was scared of this guy because he's coming at me and I was nervous. Or there's witnesses saying, hey, this guy started coming at him with a baseball bat and that guy defended himself. But there has to be a subjective component to the reasonableness. And there also has to be an objective component. Now, the objective component means from the outside looking in. So a reasonable person looking at the facts and looking at the situation could say, oh yeah, I see why that guy defended himself. Now, objective is supposed to put themselves in the shoes of the person that's defending themselves. I mean, they're supposed to use that person's point of view, but again, it still has to be objectively reasonable. And so the problems we see with objectively reasonable is, a very small woman pushes a man and the man clocks the very small woman. Or we'll see situations where grown men are beating up younger people. So, a teenager's smart enough to an old man and the teenager's poking him, pushing him a little bit. And all of a sudden the grown man goes out of his way and inflicts some self-defense on that younger person. A lot of times we have problems selling that, especially when it's men versus women, although we've won lots of jury trials with that, or older people and younger people, or people that are in prime physical shape versus younger people, especially if no weapons are involved, just pushing or some poking, and the person just goes crazy. So again, the reasonable fear of bodily harm or greater has to be reasonable from the outside looking in. That's the objective component of that. Number 4, the amount of force must be proportionate to the urgency of the situation. This is something that people get mad about, but if somebody has to defend themselves and the person that's defending themselves goes overboard, well, self-defense just goes away. And we see this a lot with home invasions. Someone is broken into someone's home and the homeowner defends themselves. In Indiana, you're allowed to defend yourself. Use some extreme force. But once the person's down, once the person has their hands over their head, once the person is trying to leave, once the person is trying to run away, homeowner continues to defend themselves a little bit too aggressively, and that just goes away. So again, if a person is defending themselves and the original attacker is on the ground, usually that's the Indiana Court of Appeals saying that person's done. You can no longer hurt them. And people get mad at me. You got to do that, Mark. You got to defend yourself. But it has to be proportionate. Proportionality is so important because, again, if it's not proportionate, it just goes away. We don't want that in self-defense. We also see people in fist fights in the street. We'll also see cases where people have neighborhood beefs or just, fighting in the neighborhood or fighting wherever, and the original attacker hits somebody, and the person they hit, well, guess what? They're pretty good at defending themselves. They knock the attackers on the ground, and then you'll see the victim do like an extra kick at the end, or they'll throw a chair at them or punch them one time when they're on the ground. That single punch, that single kick can make the self-defense claim go away. So you cannot go overboard in defending yourself. Otherwise, you risk losing the argument for self-defense. A lot of our self-defense jury trials are because the prosecutors are claiming the person went overboard. So those are the 4 requirements for self-defense in Indiana. We take self-defense very serious at this law firm. Many of our jury trials involve self-defense, and it's a powerful offense. Self-defense is basically saying, yeah, I committed the crime, but there's a justification for it. You're not allowed to hit people unless it's self-defense. So keep that in mind. If you have any questions about self-defense can get complicated very fast. We would love to talk to anybody about self-defense. In fact, we'll talk about it all day. Give us a call, 317-632-3642. Remember to always plead the fifth.